Good morning, good afternoon, good evening to everyone who watching our video. My name is Alexandre Khrapoutski. I'm partner at Lex Torre Law Office from Belarus and one of the co-chair of the organizing committee of the Eastern European Dispute Resolution Forum. Today, our guest is Gary Bourne. Dear Professor Bourne, welcome.
Thank you so much, Alexander, and thank you as well for the invitation to be with you today.
I'm confident that you do not need an introduction. If anyone does not know who Gary Bourne is, he knows nothing about international arbitration. The whole introduction could take a long time, so just as a brief introduction, Mr. Bourne is the chair of the International Arbitration Practice Group in the WilmerHale law firm. He has been ranked for the past 20 years as one of the world's leading international arbitration practitioners and the leading arbitration practitioner in London. So let me start our Eastern European Dispute Resolution Forum quick and honest interview with Gary Bourne. Maybe you will be surprised, but I would like to start our interview with unexpected and unplanned question. As I know from my own experience and feedback of my colleagues, you reply to emails in prompt way and even advise people you never knew before. How Gary Bourne, Clint Eastwood of international arbitration, can stay an ordinary person without crown on the head?
Unplanned questions are always fun. The answers, of course, also are a little unplanned. I'm afraid, though, that the answer to this question is not so surprising. I don't sleep as much as I should. I think Clint Eastwood probably also, at least in his many Westerns, didn't sleep as much as he should. It probably explains both of our respective appearances and also perhaps the jumpiness of our trigger fingers.
Thank you very much. My next question, quite complicated probably. In 1895, Mr. Vaskovsky, Russian and Polish lawyer, advocate and judge, has said, "No other profession presents such temptations as the legal profession for the morality of those who involved in it. A lawyer, being a specialist in jurisprudence, can legalize any trick, any dirty trick. It is not secret that in many cases the party wins which is more professional in arbitration and in demonstration of its position. On one hand, it leads to the award that it is based on law and facts and observes due process. On the other hand, it may lead to unfair decision that is in contrast to expectation that arbitrator will find the truth. I do not want to criticize and make any revolution by this statement, but my question, what is the main task of international arbitration? To find the truth or to issue awards based on parties' submissions and due process allegations?"
It's another difficult question, and as you rightly said, a complicated one, and I'm not sure there's a yes-no answer. It's certainly true that lawyers, like bureaucrats, like judges, sometimes legitimize or give legal effect to dirty tricks. I think arbitration, though, is particularly designed, especially arbitration in this era, to prevent that from happening. It doesn't always succeed, of course, nothing's perfect, but I think arbitration, properly supervised, has the characteristics that will both find the truth and give effect to the parties' submissions. The two often go hand in hand. So my answer to your question in sum would be that although based fundamentally on the parties' submissions, arbitration is designed to arrive at the truth. There are safeguards in place to ensure that that happens, and that the truth includes both the parties' immediate contractual dispute, but also broader questions of mandatory law that may be applicable and in that sense are part of the ultimate truth.
Okay, so let's continue and fully support and fully agree that one of the fundamental things is safeguard. But could you name 5 things in which, in your opinion, arbitration shall become better in future, or everything is fine?
So I think one of the perennial complaints about arbitration is that it takes too long and it costs too much money. I think to some extent that complaint is misdirected. One hears complaints about individual cases, and as with litigations, as with the legislative process, there are certainly instances when cases should be done much more quickly. I think arbitral institutions have made very important steps in the last decade in providing more efficient and expeditious dispute resolution. The fast track procedures for smaller value cases have caught on, first in Singapore, then the ICC, and now elsewhere. And I think provides significant benefits to the arbitral process. I think arbitral institutions have an important role in this respect. And I think in addition to saving time and cost, increasing the professionalism of the arbitral process through greater attention to the role of arbitral institutions is the second point that I would address. I think a clearer understanding of what constitutes independent impartiality of arbitrators is also a critically important aspect of the arbitral process where further improvement would be desirable. I think in particular, there has been a muddling or confusion, if I can put it that way, of the grounds for challenging an arbitrator for lack of independence during the arbitral process and the grounds for setting aside or annulling an award or denying recognition of an award at the conclusion of the arbitral process. I think it's vitally important that these two separate issues, removal of an individual arbitrator and on the other hand, annulment or non-recognition of an award, be kept quite separate. I think that the New York Convention is sometimes identified as a fourth area of improvement. We should have a new or recast New York Convention. I think that's unwise. I think the New York Convention has stood the test of time, has provided a workable and indeed extremely important foundation for the international arbitral process. And in the words perhaps of Clint Eastwood, if it ain't broke, don't fix it. And I think that would be my advice with respect to the New York Convention. Finally, although not exactly in the world of arbitration, I do think it's worth mentioning the Hague Choice of Court Agreement Convention. And my advice there is, it is broken, so don't ratify it. The European Union has been quite active in encouraging states, both in its neighborhood and elsewhere, to ratify the Hague Choice of Court Convention. I think that would be a dramatically bad decision. I'd be happy to say more about that in another forum, but hopefully countries will rethink the Hague Choice of Court Convention in the coming years and both not ratify it, and if it has been ratified, to unratify it.
So it's a very interesting topic, New York Convention. In your opinion, when may such changes become real perspective?
I suspect, and this is a personal view, I suspect the New York Convention will not be amended. There have been proposals in the past, on its both its 50th and its 60th anniversary, for amendments to the convention or for an entirely new convention. I think that the fundamental reality is the convention has worked very well. There are areas where one can think of possible improvements, but for each of those improvements, there are multiple views as to what the right approach for something new, some amendment would be. In those circumstances, I think what has happened with the convention over the past 60 plus years is actually the best way to proceed in the future. And what has happened is a combination of practitioners like yourself, legal academics, and judges have interpreted the convention in specific contexts, giving meaning to sometimes ambiguous language, ultimately producing a relatively uniform set of interpretations that gives the convention more force, more efficacy in day-to-day practice. I think that process, the quintessentially common law process of fleshing out a broad set of principles, is a better approach than attempting to legislate a new all-inclusive code for international arbitration. In my view, that effort would be entirely inconsistent with the historic flexibility and evolutionary character of the arbitral process.
Thank you very much. Let me return to one issue you mentioned in previous answer, which is one of the most criticisms of international arbitration: cost. There is an opinion that international arbitration intended for big companies with high amount of dispute. In some cases, arbitration is just unavailable for middle and small business due to the cost of arbitration. Do you think that's an option, the Prague Rules could become the tool that may be used for small and mid-sized businesses in small cases?
That's an important question, and my answer may not be very well received in Prague, perhaps elsewhere in some parts of Central Europe. I think that the most important thing that can be done for reducing the cost of arbitration, not just for small and medium-sized companies, but also for individuals as well as large public companies, is use of fast-track procedures for smaller value disputes. Those, in a sense, by definition, are what are most likely with small and medium-sized companies, often what's most likely with individuals. A fast-track procedure that requires rapid appointment of an arbitral tribunal, typically a sole arbitrator, and award within a specified period of time, typically 6 months, with an escape valve for extraordinary and unforeseen eventualities, a cap on the arbitrators and also the arbitral institution's expenses. I think that type of rule regime, which exists in the Singapore International Arbitration Center's rules, now exists in the ICC rules, exists in some other institutional rules for smaller value disputes. In the case of Singapore, around 4.5 million euro. In the case of the ICC, somewhat lower, closer to 1.5 or so million euro. I think that is the most important step that one can take in containing costs. I hesitate with respect to the Prague Rules. The reason I hesitate is for the same reason that I hesitate with respect to a recast or more comprehensive New York Convention. I think it's dangerous to attempt to legislate across the board for all cases. I think the better approach is to allow the parties, on the one hand, and the arbitral tribunal with its procedural discretion on the other hand, to design procedures for individual cases. That may include, in some cases, some element of disclosure. It may, in other cases, not provide for disclosure. It increasingly can provide for remote hearings, like this interview being conducted on an internet platform instead of in person. That too reduces significantly the time and costs of an arbitral proceeding. I think those approaches, things aimed at limiting the overall time that is spent, make more sense than attempts to micromanage both the parties' procedural autonomy and the arbitral tribunal's procedural discretion.
Thank you very much. Let's touch upon another very important issue in current arbitration and in future of international arbitration, the role of arbitral tribunal. One professor from my university has said once, as soon as students start to speak, I already understand whether he knows the subject or not. For me, this could be applied for arbitrators and counsels. One of the issues for discussion is the increase of arbitrators' proactive role in proceedings. What is your opinion with regard to preliminary reviews of arbitrators after submissions of the parties and giving arbitrators instructions how to clarify parties' positions. It also, in my opinion, will be helpful for criticism of two main things, time and cost.
And so, short answer to your question, I do think arbitral tribunals should give indications about where they have difficulties with one or both parties' cases, but I don't think arbitral tribunals should mandatorily require that certain modes of presentation be adopted or certain lines of argument not be pursued.
So arbitrators are humans, but let's touch upon artificial intelligence in international arbitration. As we are aware, Clover scheduled for release interactive artificial intelligence in 2043 that will answer by your voice to questions about arbitration. Do you personally afraid that one day arbitration practitioners may remain out of work due to technologies? And to what extent technologies may intervene into arbitration?
Alexander, that's a great question, and I think it's one that has particular importance to the younger members of our audience. I suspect that in the next 20 years, the professional lives that you and I lead probably won't be dramatically affected by arbitrator intelligence. I don't think that an algorithm will replace either of us, whether as counsel or arbitrator, in the next 20 or 30 years. I also think that artificial intelligence in the longer run probably does pose a threat in a way, perhaps a benefit in a different way, to not just every profession, but everything humans do. If an arbitrator can answer a question in an interview like this, if an algorithm can answer a question in an interview like this better than I, or can put the question better than you, then there won't be any reason to have investigative reporters or political figures. There won't be any reason to have chefs or hairdressers. It can all be done by machines. I suspect that arbitration is one of the last strongholds of humans that would fall to the march of artificial intelligence. I can't say for sure, though. Perhaps we should ask the computer what the right answer is.
This is the reality that the last year I can say we already changed our lives into online format. So do you think that online format is going to be the rule more than the exception in a post-pandemic world? And if arbitration would we become even more document-oriented than before?
It's a great question, Alexander, and I thought about that myself outside the context of this interview. First, I do think that remote hearings, remote procedural conferences, the use of technology in the arbitral process is here to stay. When the pandemic is finished, when lockdown and social distancing is hopefully a memory, the efficiencies that we've learned as a consequence of the pandemic will continue to exist if we use remote technology. Clients will insist upon it. Perhaps arbitrators will insist upon it. I have to say, I've heard many people say they're a little bit pleased about not having to get on the airplane to fly to the Philippines or Vancouver or what have you as a consequence of social distancing. That said, I think there are many categories, or at least some categories of cases, where in-person contact in-person hearings, in-person meetings will continue to be essential. There's something that is added when you can hold up a physical item and inspect it in a group, when you can see a witness in person. To some extent, that may be exaggerated. It may be that seeing a witness in person is something we've been used to in the past, but seeing her or him on a television monitor is an entirely adequate substitute. I don't think we know enough quite yet. Whatever the case is, though, I think the future is not an on-off switch. It is not a case that remote technology will entirely replace in-person hearings, or alternatively that in-person hearings will be the rule as it was in the past for virtually all cases. I think there will instead be a middle ground. And I don't know where exactly that middle ground will lie, but if I had to bet, it will use a lot more remote technology than we probably think it will today.
You're known to be the BAT's Bilateral Arbitration Treaty father. Could you please briefly explain your proposal and tell us about its further life?
So it's a topic that is near and dear to my heart. I think it's one that would be perfectly suited to Belarus and other states in the region. The basic concept is the following. In many cases, an important number of cases, parties fail to provide for any dispute resolution mechanism in their contract, perhaps because it's the nature of the industry. Contracts are formed rapidly and without extensive documentation. Perhaps it's because of carelessness on the part of one or both parties. Perhaps it's because of simply a lack of attention to detail. In those cases where there is no arbitration agreement and no choice of court agreement, the basic concept of a bilateral arbitration treaty is to provide for a default means of dispute resolution pursuant to a standing arbitration agreement, which will apply to parties, international parties, where they have not otherwise agreed on how to resolve their international commercial disputes. And this is not a proposal that interferes with party autonomy. Parties are free to agree on alternative mechanisms, either arbitration or expert determination or litigation in national courts. It is also not a proposal that affects consumers or labor unions or the like. Instead, this is only business to business. It only involves international commercial disputes between merchants, between economic businesses on both sides of the dispute. In those circumstances, though, our current means of dispute resolution, I would submit, is broken. In our current means of dispute resolution, at least in most countries, if there's no agreed means of dispute resolution, you very frequently have parallel litigations in both parties' home jurisdictions. Each party seeks the most favorable forum for resolution of the dispute. And that can, in many cases, end up with a litigation in each of the two parties' home jurisdiction. That's not satisfactory to either party, particularly given the difficulties in the recognition and enforcement of foreign judgments. What makes more sense is for there to be a default means of dispute resolution in cases where the parties in an international commercial transaction have not otherwise agreed. A prearranged means of dispute resolution, international arbitration, would provide the fairest and most efficient means of resolving those disputes. It would bring all the benefits of arbitration to parties that lack the foresight to agree upon it, but leaving the parties free if they wish to agree otherwise.
Let me ask you one more question regarding the words. As all we know, sometimes the words may be high volume. It may be even difficult to read them, not saying about full understanding and remembering details. Is it possible from your point of view to return to the old American Arbitration Association model? This party wins, the other party loses. Here are the 5 pages as to why.
That's a great question, Alexander. And I have again, a sort of multi-part answer that's not an unconditional yes or unconditional no. First, parties already have the freedom, as they have historically, to agree upon so-called unreasoned awards, simply the tribunal announcing who wins and who loses, who has to pay how much money. Parties, that's the case under the UNCITRAL model law and most national arbitration legislation, which doesn't encourage parties to agree upon unreasoned awards, but if they do so, explicitly will give effect to that agreement. It's not a ground for annulling or denying recognition of the award. Commercial parties typically don't exercise that option to agree upon unreasoned awards. Instead, parties typically leave in place the presumptive default rule that exists in the model law and elsewhere, namely that the tribunal has an obligation to provide a reasoned award. And that obligation in turn has led to the 100 or 400-page awards that you referred to in the question. Commercial parties in larger cases, I think, want the security that they believe comes from a reasoned award that provides a basis for ensuring that the tribunal has actually considered the party's arguments. It provides an explanation for why one party lost and the other party won. In a sense, it's another safeguard for the parties in the arbitral process to ensure that the arbitral tribunal actually pays attention to their submissions, actually grapples with the arguments that they've put. All that said, I think that some of the rule changes that have occurred in the last decade move in the direction, perhaps not entirely to what you suggested, but move in the direction of what both you suggested and the historic American Arbitration Association approach was. Namely, in the smaller value cases that we discussed previously, cases of less than, say, $5 million or euro, arbitral tribunals can provide a summary award, a summary of their reasoning. It isn't expected that in a fast-track arbitration to be conducted in 3 or 6 months that the arbitral tribunal would write a 400 or even a 100 or 50-page award. Instead, a summary of what the issues were and how the arbitral tribunal resolved them is all that's contemplated and all that's required. In that sense, I think the arbitral process has demonstrated its historic flexibility and diversity. In large, important disputes, more care is required. A fully reasoned award is necessary, including matters that might, to an outside observer, look like boring procedural points. In smaller value disputes, where a little bit like traffic cops, arbitrators are simply supposed to process some claims, a much more summary approach is appropriate, and what commercial parties increasingly are looking to arbitral tribunals to provide.
Thank you very much. Now I proceed to the last part of our interview that will include 10 questions that will require maximum 10 seconds brief answer. So, are you ready?
Like speed dating.
Okay, let's start. My first question. When you imagine arbitration in 100 years, can you name 3 words that reflect it in the best way?
Fast, fair, and free.
Great. The second question, if you had the choice, what you would choose? To pay for consideration of the case by human arbitrator or artificial intelligence, but free of charge?
Decision of the case by some humans.
Thank you. Do you believe that arbitration in a week may become available?
I do indeed. In the Olympics already, arbitration in 24 hours is available.
Great, thank you very much. What would you personally prefer, online or offline hearing?
It depends on the case. Some cases online, other cases in person.
Yeah, as lawyers, we always say it depends.
It depends.
As it was said by Ambrose Bierce, international arbitration may be defined as the substitution of many burning questions for a smoldering one. Do you personally agree with such statement?
I don't understand Mr. Bierce's metaphor. And insofar as I do, I agree that arbitration avoids or answers many burning questions, but I don't think that it produces a smoldering result. Rather, in most cases, a very cool result.
Thank you. Can you name 5 things that are the most needed to win the case?
Work, 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 work.
Thank you. In your opinion, will London be affected as a preferred arbitration seat because of Brexit?
I think that's a hard question. I don't believe that it will. In principle, it shouldn't. The New York Convention remains applicable in just the way that it was previously. I think, if anything, avoiding the excessive regulation in some fields of the European Union may make arbitration in London even more attractive than historically was the case.
The next question, what feature of client is better for you? Ability to pay high fees or comfort in work?
I would always prefer to have a client that was comfortable with the work that we did, happy with the work that we did. In the long run, that ensures a satisfactory economic return, and having happy clients is better than just about anything else.
Thank you. If you let me allow, what will be your next book?
I'm working on a book on international law in American and also other courts. It branches out from or expands from international arbitration per se, and looks much more broadly at the role of international law in our lives today.
Thank you. And my last question, what day in your arbitration life would you like to live over and over again, like in the movie Groundhog Day?
Well, there are many days that I wish I could have skipped. I think if I could pick one day, it would be the closing arguments in the so-called ABA arbitration.
Dear Professor Born, it is time to thank you again for this very interesting, quick and honest interview. It was our big pleasure. Thank you very much.
Thank you so much, Alexander, and thank you again for the opportunity to do that.